or those employees as per schedule 2. Like go back to schedule 2 which we have discussed. You will find, like, or else go to the internet and try to find what does schedule 2, who are the employees which fall under this. Alright, but it does not include members of armed force union. Alright, I hope you guys are understanding. Now employees done. Now going back to chapter 2, section 3, workmen's compensation, the name of the chapter. And section 3, it speaks about employers' liability for compensation. Now, the one which we had doctrine, forget about it. It was before this enactment of this act. With respect to this act, when can an employee get the compensation, or when is the employer liable to pay compensation? So let's talk about it. Employer liable to pay compensation if personal injury is caused to workman by accident. Workman, there should be an accident, and injury should be there. I'm not marking it because it's a paper. Arising out of and in course of his employment. Employer shall be liable and shall not be liable if shall be liable till here. Okay, in the course of and arising out of employment. I have already explained this, but then let me tell, out of employment and in the course of. Let me just say, there is no point, there is nothing wrong in explaining it. Out of means there should be some connection between the accident or injury with respect to employment, right? Yes or no? I have talked about it. And then in the course of, it means within the time period. Let's say you go to the office at 6 and come out 6 time frame, within the time frame, and if it is within this factory premises, then employer is like liable. But let's say like your work was within the factory, but you went away outside just for having time also whatnot, then you won't be getting compensation if you like die outside. But let's say for other purpose, if you go for other purpose and you have died outside, then you will not be paid. But let's say like during the lunch period, you were inside this premises and you have like died or like injury occurred, then you will be paid compensation. Alright. So these are the few. Now employers are liable to pay if accident arise in the course of employment and out of employment. So these two keep in mind always. It might be asked in exam. So when is employer liable? Now he is not liable. We spoke about liable, and second, he is not liable. That means he doesn't have to pay. When? First, injury does not result in total partial disablement exceeding 3 days. 3 days. Let's say you fractured your hand, and it so happened then within 2 days you are alright. You're not gonna get any compensation. Why? Because to be eligible for compensation, be it total or partial, it has to exceed 3 days. Keep in mind, 3 days. More than 3 days. Number 1. Number 2, injury caused by an accident. Okay, injury, you got an accident, you got an injury, alright? Due to influence of drugs, drink. Let's say the worker, he was like tired or fed up of the job, and let's say he just drank whiskey, wine, whatever, and he was like full in somewhere, in a second heaven, let's say. And he was working, and out of a sudden he felt that he was a Superman or a superhero, and he jumped down, or let's say something fell over him and he is injured. He's not gonna be paid any compensation. Why? Because he was in the influence of drugs or drink. Right. Second point gone. And third point. willful disobedience of rule and willful disobedience of rule. That means what? Willingly he disobeyed the rule. He was asked not to use this, let's say this staircase, but still upon reminder he used, and then accident occurred. Who's gonna be blamed? There was already written clearly like not to use, do not, but still he broke the rules, or let it be any other things like he broke the rules, then also he's not gonna be paid. Third case. And what is the fourth case? What does it say? Willful removal of any safety guard. Now let's say when you are working in a manufacturing company, you get a helmet and everything works, right? If you're working in a very chemical exposure thing. But he was like, what, nothing happens to me, I'm the hero, and he's so there like herogiri. And he got accident, let's say. He's not gonna be paid any compensation because willfully he removed that safety guard, and you cannot remove that safety guard. Yes or no? That's it. So going back to the next slide. Now we spoke about when it is liable or when it is not liable. Now if it is liable, how much is liable? It means the amount of compensation. Basically it's very simple, like you see, it talks about compensation. If it is liable, when, no, yes, and then how much, then done, then khatam. It's over, compensation. And employer also happy, and I am also happy, employee is also happy. Okay, let's go. Amount of compensation. Now you see, we talked about injury, right? But it so happened that that injury caused him to death, Maria, death. In the case of death, how much amount he will be paid? 50% of monthly wages. 50% of monthly wages. Okay, I'll be like calculating this in the last slide and explaining you. And into relevant factor. Yes or no? 50% of wages into relevant factor into what? Into that must only 50% of wages into relevant factor, or 1,20,000. Okay, this has been amended, I think, with respect to 2010, I guess 2010 or something. I guess it is 10. Before it was 80,000 or 80,000, right? See, now what I'm trying to say, amount of compensation. Now let's say due to injury, employee that injury result in his death. So he will be paid 50% of wages into relevant factor. Relevant factor will be given like 216.1, 215.1. There are various relevant factor for various type of injuries, or 1,20,000, whichever is more, right? And to calculate this wage savings should be 8,000. Keep in mind, this is very important for numerical based solving. 8,000, it cannot be beyond 8,000. Let's say you are earning 21,000, but still wage savings should be taken as 8,000. It is 50% of 8,000, and it is 4,000. Now going back to the next, in case of permanent total disablement, here death, here permanent total. Permanent total means, I explained, no more use, like cannot work anymore throughout your life. You're gonna like your earning capacity is zero earning capacity, zero earning capacity. So in this case, you will be paid 60% of wages into relevant factor, or 1,40,000. Whichever is more, right? I hope everybody understood like this thing. So in case of death, it's 50% or 1,20,000, and in case of like permanent total disablement, it's 60% of wages into relevant factor, or 1,40,000, whichever is more. Now, half monthly payment of 25% of wages. It's for partial disablement. I forgot to mention it. I'm so sorry. It's for partial disablement. Alright. So here, if the disablement lasts for 28 days, let's say disablement means what? And to be eligible, you have to be disablement should be more than what? 3 days. Yes or no? Yes, 3 days. It should exceed 3 days. So disablement lasts for 28 days or more. Let's say it's 28 days or more. The monthly payment is payable on the 16th day. See, this is very important. If it is more than like 28 days, then on 16th day of every month it should be paid. This is a very common question. It is to be asked in the exam. Alright? Now, if the disablement lasts for less than 28 days, after the expiry of waiting period, that is waiting period is how much? At least 3 days from the date of disablement. Thereafter, half monthly payment during the disablement or during a period of 5 years, whichever period is shorter is to be made. Okay. Let's say the expiry of waiting period of 3 days from the date of disablement. Thereafter, half monthly payment during the disablement or during a period of 5 years, whichever period is So here what it says, see, half monthly payment should be done. Okay, let's say after 3 days you are eligible. Yes or no? So half monthly payment you can get from this more than 3 days to up to how many years? Maximum of 5 years. Okay, from let's say 4 days or something to 5 years, and beyond 5 years you are no more eligible. So this also comes during exam also. And here some more lines is there. I can see in my laptop. I do not know why it doesn't come here. I guess because of the zoom. I'm so sorry. Whichever period is shorter is to be made. Right. So it can go up to 5 years. Like half monthly payment, like you say this month, next month, up to how much he can get compensation up to 5 years. Keep that in note. Now, things to know, like some cases which I have collected. So now let's discuss one by one. Will the dependent of an employee working as a substitute for one day be entitled to compensation? Like let's say I'm working and my dependent is coming and working instead of me for 1 day. Will it be like eligible for compensation? Yes. Now how do you know yes? Please read this case. New India Insurance Company Limited versus Mohan. Try to read. It's with respect to bus driver. Alright? It talks about this and you will get a complete like story about it. I'll just like explain to you one minute. Read the case. See, laws or something like if you read practical cases, you get to know. Because I am also not dealing with any laws, right? I just read and understood, so I am explaining. You try to read, then you get lots of knowledge too. And second, is appointment letter necessary to fall in the category of workman? Now, see, for an employee or for a person to say that he is a workman. So is it necessary that always a formal appointment letter is necessary? Like you have to prove it here? No, it is not. Why? Workman is very wide. In the definition of workman, can you define just workman as the is that you can? It's very wide. So we want from which like cases it was said that it is not needed. United Indian Insurance again. This is New India. Sorry, United Company Limited, Hyderabad, and Anjayulu and another 2007 case. Try to read this. In this case, they were told that appointment letter is not necessary to fall in the category of workmen. Now, next, is compensation payable for physical disability which results in no loss of earning capacity? In the first slide itself, what does it say? There should be an injury, there should be a reduction in loss of earning, then only you are what? Eligible for compensation. Yes or no? It clearly indicates. So it will be no. Obviously, you like when? How can you even say like there is a loss of earning capacity? Like you got an accident, but nothing happened to you. So there is no loss. So why you be paid compensation? And with respect to this act, you are not gonna be paid. And this judgment was given in the case of Calcutta Electric Supply Corporation. Try to read this also. If you want to, I'm not forcing you. Now, second coming back to the fourth. Can snake bite be termed as accident? Snake bite, scorpion bite, whatever. Yes, in the case of Taj Khan Hussain versus Patel Prava, it was decided that death of workman due to snake bite while on duty, remember it, I told you, will amount to accident. It means accident. So, the main point is that the accident must arise, see, main point see here also, must arise in the course of employment and result in, yes or no? Out of, they didn't add one more. Arise in the course of and out of employment. Okay. We have spoken about this 2 points are very important. Everywhere you see, we are finding again and again. Now going back. Now next, important conditions to be fulfilled for employer's liability to arise. We have like spoken about this also, but then again, like let's say a capsule type, there should be what? Personal injury. So it must be caused by accident. And accident arises out of and in the course of employment. In the course of employment, accident. Okay. Arise out of and in the course of employment. Accident. It should arise in the course of employment. Yes or no? See again and again this time there should be, of course, accident arise in the course and out of accident, but there was no injury like the earlier case. You will not get compensation. So what does personal injury implies? It's physical or bodily injury, right? Caused by an accident. However, it will also include mental strain or nervous shock or breakdown. For example, it may also include heart attack while on duty. It will be considered as accident. So these are the few things which you should keep note with respect to like understanding plus exam purpose. I hope like everyone is clear. So let's get to another. Now one more, like this is with respect to like substitute. See, fired by an army personnel, Goli, shoot down for stepping down slowly from the truck driver. An ill truck driver was dead. The cleaner of the truck driver was driving as the driver fell ill. Will this even be considered to arise out of and in the course of employment? So what does it try to say? It says that there was a driver, okay, me or anyone. Let's say A was a driver and B is a cleaner. Okay, he is the official driver, but on the way, in the course of employment, A fell ill. When someone falls ill, obviously he will not be able to drive. Yes or no? So B, what he did? He tried to he took the change over. Like B started driving, and A was like sitting in the rear seat and coming. Yes or no? So now B is the driver. Now on the way, army personnel, they stopped him. Hey, come out. B got down, but A could not go down very fast. He was coming down slowly. Why? Because he was not well, right? But then what happened? Army personnel, they were like furious and they shoot him, and he was dead. So will he be considered in the course of employment because he was not driving? Actually, this is what the question wants to say. So yes, this judgment was given in the case of United Insurance Company versus Nirmal Court. Again, the deceased worker was working as driver. He fell ill after loading the truck on his way and asked the cleaner to drive the truck. So this is this case, right? This will be taken as arise out of and in the course of employment. So I hope you got the scenario of what basically and how it applies to. Now everything is done. This much is eligible, this is eligible. See, liable or not? If liable, how much we have discussed, and what are the cases, and cases what are the types taken into accident, and how much will be payable, we have discussed. Now after deciding all these things, the amount and everything, now comes when to pay. Now section 4A states that the compensation should be paid as soon as it falls due. Suppose today is the day that they have to be paid, then they have to be paid. Alright. Defaulting payment. Now what happens if it doesn't pay in time? In case the employer does not pay the compensation within 1 month from the due, let's say 1 month today to next month, the commissioner can direct the employer to pay in simple interest on the amount, 12% per annum, or at such higher lending rates of any scheduled bank. You got 12% per annum if you do not pay within 1 month of the due period. Okay. So this is in the notice and claim. Section 10 talks about the claim. Claim means what? Now the commissioner, who is the commissioner? He is the one who looks after all this thing, right? So let's say he looks after all those employers, whether they follow this or not. Like Factories Act, they have inspector. This Workers' Compensation Act, they have what? Commissioners. So it's the claim must be made within 2 years. Like let's say some decision have been taken and with respect to like accident or death. Okay, like I am not satisfied. Now I need to claim it. I should claim within when 2 years of occurrence of the accident. Right. After that, there is no point. Now, obligation and responsibility of employer. What are the duties of employer? Right. See, like let's say employee dead due to accident. Let's say like A died in an accident. A died in an accident. Now this employer has to report it, yes or no, to the commissioner that died, or the commissioner can direct him like what has happened is. So employer has to submit the cause within 30 days. Like A have died this reason, why not this, he have to explain it. And it says one more thing. If suppose A died, now I am the employer or anyone is the employer. If the employer thinks that I am liable, or if I am the employer and I think that I am liable, I should pay the compensation within 30 days. The employer should pay the compensation within 30 days. Alright. And if I feel that I am not the liable person, I should explain on what fact that I said that it is not like me who is liable. I have to like prove them the grounds on which I disclaim. Alright. I have to prove them that no, it's not me. Alright. Otherwise, if I think that I am, then I have to pay within 30 days. If not, then indicate the grounds on which I disclaim. Right. Now going back, seriously bodily injury. So seriously bodily injury or fatal accident. Like if fatal accident happens, now employer has to report to commissioner within how many days? Within 7 days. This is a very important again for exam purpose. Serious body injury means what? Permanent injury or permanent loss of what? Sight or hearing, or fracture of limb or absence of injured person for more than 21 days. If it is more than 21 days, then also it is known as seriously bodily injury. Alright. Now medical examination. Like let's say I got accident. Yes or no? Now to pay him compensation, I have to examine him, right? Or else he may be saying that sir, I'm not well, I can't work, and I'm like sleeping in it nicely and enjoying the compensation. And the company is a mad guy, so he will believe and say, okay, fine, you sleep and you come tomorrow after when you get alright. Yes or no? So that cannot be right. So like he got accident. Now let's say I am an employer. I will call him for, okay, fine, come for medical examination, so that you are eligible for what type of benefit we have to see. So, yes or no? And that time, let's say he refuses to come within 3 days. He didn't come in 3 days. Then his compensation will be suspended. Yes or no? Yes. Okay, one more thing I forgot to tell, so sorry. Let's say like partial disablement. Yes or no? Like one finger loss, right? 4 finger loss. That is partial disablement. That means 50% of arm. Yes or no? And now let's say one more arm is gone. This is also just going. One arm is also partial, right? Because one more arm is there. It is. So this is also 60% of. See what I'm trying to say. When you lose 4%, there are some percentages. Right? Just go through the book. You will get. So 50% loss of earning. They calculate means different. So basically, I remember because of this person. And now let's say one hand is amputated. So it's 60%. Now total is what? 100%. Now what it says? What I'm trying to say? If a group of like partial disablement, okay, partial disablement means half disablement. Partial disablement, if group like taken in a comprehensive way as a whole, like one, and like when we total it, if it is more than 100 or 100%, then it will be considered as permanent total disablement. So in this case, just fingers loss is 50% earning loss, right? and also arm going away is 60%, so total 110. So it is singly when taken, is like it's 50% and 60%, but as a whole when compared is 110. So this will be considered. Now let's proceed to section 15. It talks about special provisions relating to master of ship and seaman. So they fall under the what employee, right? We have like seen in the previous slide too. So what it says, like if there is an accident or anything, like it should be claimed to master of ship. But if it happens on board, then you don't have to give notice, right? Now what it happens? Claim in case of death of master or seaman, it should be made within 1 year. But just in case if the ship is lost, then they get a chance of 18 months, time of 18 months again. Same case with section 15A, captain and crew of aircraft. So for them also it's same, that's 1 year, and if it's lost, they get time of 18 months. Alright, for claim. This is also very important. Now going back to penalties, yeah, of course in any like acts there are always a penalty. So in this case too, like if let's say if the employer fails to maintain a notice book of accident, like how much accident happened and whatnot, and fails to submit to commissioner a statement or a report or let's say return, then as per amendment of 2017, mark it. Penalty increased. Before it was 5,000, now it's 50,000, and it may extend to 1 lakh. 1 lakh. Alright, not a lot. It's 1 lakh. I'm so sorry. Now commissioner. We have I have discussed like who is the commissioner. And to appoint this, like what are the basic like qualification or experience needed. So appointment of commissioner, state government may appoint, and what he has to be at least a member of state judicial service for a period of not less than 5 years, an advocate or pleader for not less than 5 years, gazetted officer for not less than 5 years, having educational qualification and experience in personnel management, human resource development, and industrial relations. So these are the 3 points. Any one of them can be appointed as commissioner by state government. So please keep note of this. During exam time it counts, and it came too, I suppose. Now it was also like inserted with 2017 Act, I guess. It was section 17A talks about what? Intimate right of compensation. So employer what na? He should like make sure that he should inform his employees the rights to compensation at the time of employment. Like let's say today you are coming to my factory, I should inform you like your right that as an employee you will be getting the compensation. So through writing as well as through electronic means, through email, whatever it is. It should be in English, Hindi, or official language of area of employment. If it's in Guwahati, let's say local language would be Assamese. So English, Hindi, or Assamese. Or let's say Kolkata, English, Hindi, or Bengali. Right. Now we have come to the end of this chapter, and I will be explaining in brief what were the amendments in 2010 and 2017. Right. So in 2010, employee, before it was workman compensation, but now it's changed to the name as employee. Yes or no? And second thing, compensation payable on death from injury increased from 80,000 to 1,20,000 and 50% of wages. And before it was 90,000 for permanent total disablement. Now it's 1,40,000 or 60%. I have explained this, but just I'm giving you a glimpse what has happened in 2010 and what has happened in 2017. In 2017, employer responsibility to inform. See, I have told this. Okay, and now penalty 5,000 is now 50k to 1 lakh. Right? Appeals if amount of dispute is rupees 10k before it was done. See, for any appeals, let's say I'm unsatisfied or I am have to get some compensation or I'm not getting, the dispute cost or the amount of dispute relating to this compensation, it should be at least minimum 10,000. Otherwise, you cannot appeal. Before the amendment of this 2017, the minimum amount was what, 300. Who will even go for 300? I will. So down the line, due to inflation and money value is decreasing, so it might be the case. So at present it's 10,000. This is very important again. All these things are very important. It's latest amendment, so it's very important. Now let's see, like, whatever I have explained to you, let's check like you have understood or not. So we'll discuss one by one and we'll wind up. So first, as per Compensation Act 1923, employer is required to submit reports bodily injury. I have spoken about this. And fatal accident within how many days? 3 days? No, 3 days is like to be eligible for compensation. You have to be more than 3 days. Yes or no? For bodily is 7 days. Now second, if there is willful second question, if there is willful removal, means willful money upon my will or employee's will, okay, or disregarded by the workman of any safety guard or other devices which he knew to have been provided for the purpose of securing safety of workmen. So here it says that now me or an employee, like he knowingly removed his safety guard which he knew that it was provided for him for the sake of safety. Now I, knowing the fact that I should use that, I removed it willfully. So am I like eligible for compensation, or is the employer liable for compensation? The answer is what? We already like read about this. There are 4 points. One is if he is drunk, second is removing willfully, and third is not following the order. Yes or no? So employer is not liable for compensation. It's simple, right? So going back to the next slide. Now, the Workmen Compensation Act 1923, the Maternity Act 1965, and the Employee State Insurance Act 1948. Together, can it be applicable? The Maternity Benefit Act and the Employee State at a time? No. The Workmen Compensation Act, the Employee State Act can be applicable at a no. If the Workmen Compensation Act and the Maternity Benefit Act are applicable, the Employee State Insurance Act is not applicable. Why? Because see, in the ESIC Act also you get lots of benefit, let's say for funeral, for maternity. Again, if you are getting for maternity, again you are getting compensation here, because here also you have been provided compensation. Can you get to compensation? No. So either one of them you have to go. So this is it. And Workmen Compensation Act is like very comprehensive social security. So you have understood. This is the answer, and it is very important again. Now, if after the accident the worker has become disabled, okay, and cannot do that particular job, the job he was doing, he cannot do that job, but the employer offers him another kind of job, the worker is entitled to compensation to what? What type of compensation? So what compensation of what? What is it called? Like it says that a worker, like due to like accident or anything, he was disabled, but the employer gave him a second option, like you can work this instead of that, as you are not like able to work that. Alright. So what shall we call it? Shall we call it like total disablement? Of course not, because he can still work, right? Up to some at least a bit, or let's say 50%. So it will be partial disablement, because he can still work. See, offers him another kind of job. Yes or no? He could not do that particular work, but other employment he can do. So it will be partial. Now, calculate the amount of compensation that an employee is to be paid who suffers from permanent total disablement. We know there are 2 points. One is debt. That means what? It is what? 50% of wages into 11 factor. And permanent disablement is equal to what? 60% of wages into RF. Now I told you, see, RF is given to 16.91, so 60%. and we know wages is 21,000, but there is a wage ceiling, no? Which I have spoken about this, means I have explained, speaking ceiling is what 8,000. You may earn 30,000, 15,000, 21, 20,000, but only till 8,000. Yes, 60% is by 100. So cut 8 6 4800 into RF 216.91. See, multiply this and you will get the answer as this. But if you do by mistake, let's say you forgot to put 8,000, instead you put 21,000. If you forget, you will get an answer this. So both are an answer. During exam time you will be confused, are this or this? Keep in mind, the main concept is 8,000. Alright? I guess everyone is very clear for 2 days. So today we have basically learned most of the things. Of course I have left some, but these are the various important things with respect to like exam purpose. And I have also selected it with from my another book, which explains about all this. So I have covered up mostly everything. So I guess like everyone is very clear. So with this we end our lecture here, and I thank you guys for like watching it and learning something from it. Request you to kindly provide me your feedback, and down the line I'm gonna bring another lectures, so keep liking and do subscribe. Thank you so much.